As America continues to struggle with the coronavirus pandemic, today we're talking about getting back to work and some of the legal questions that companies are facing as they're welcoming their employees back into the office. Hello and welcome to TalksOnLaw. I'm Joel Cohen. Today we're joined remotely by Ira Kustin and Sara of the law firm Paul Hastings. Ira, Sara, welcome to TalksOnLaw.
Thanks so much, Joel. It's great to be here.
Thanks, Joel. Appreciate you having us on today.
Well, before we get into some of the details, maybe you can lay a little foundation. What are we seeing out there in terms of companies?
Joel, I think the state of the market is a bit all over the place. For clients like mine, hedge fund managers, private equity fund managers, managers of all sorts of private funds, my impression is that most are still working remotely. That being said, there are some private fund managers who do have personnel in the office and are trying their best to adhere to whatever guidelines are being issued. That obviously is going to depend on what market they're in and what local law has to say about it.
Sara, you are a labor and employment specialist. Why don't you walk us through what are some of the guidelines or regulatory hurdles that companies need to be thinking about?
Sure. Well, we've all heard about the various guidelines that have been coming out, whether it's from OSHA, the CDC, or state and local guidance. That guidance has been constantly changing. And so it's difficult for companies to say what guidance prevails. So it really becomes a matter of risk tolerance. If at the end of the day, your biggest concern is litigation risk and what is most defensible, you really need to think big picture then and implement and follow the most restrictive guidance, even if it isn't binding law.
So your advice is to go to the extreme of protectiveness.
Yes, absolutely. The extreme of protectiveness, because at the end of the day, that is most defensible, and that's going to be what most companies are most concerned about. What's their litigation risk? And landlords, going one step further, expect you to maintain a workplace that is free from hazards. And so that piece of it, the reasonable steps that you need to take to maintain a safe workplace, really is to follow the guidelines. And when you're looking at two separate guidelines, the more restrictive is going to be the best defensible.
Ira, you're advising clients on this. What are you telling them as to what they should be focused on?
A couple issues that the SEC will definitely be focused on are business continuity plans and cybersecurity.
When you say business continuity, Ira, are we talking about in case one of your employees comes down with COVID or is unable to perform their duties?
You know, it includes those, and I think it goes beyond it as well. After Hurricane Sandy, the SEC really started to focus more on business continuity plans. And, you know, obviously that was in the wake of a natural disaster. But at the same time, the SEC really does expect advisors to be planning for all sorts of contingencies or emergencies. And so that not only includes perhaps planning for data backup, for alternate locations, for the operations of your business, enhanced attention to working remotely and remote access. And that obviously dovetails with cybersecurity requirements as well.
So continuity is, like you said, about more than just individual employees. It's about the infrastructure. On that note, you mentioned cybersecurity. Is that part of the continuity plan or also something different?
It's definitely a part of any business continuity plan, but the SEC is also focused separately and has been for some period of time on making sure that advisors have robust cybersecurity measures in place. And this includes really an active, ongoing reassessment of the measures that you have in place, the types of data that you collect and store, not only from your investors, but also from counterparties, and all of the information that an advisor needs to store with respect to trading and your portfolio.
Has the government jumped in and given some specific guidance whether it's on the cybersecurity front or related to business continuity and cyber risk?
Yes, Joel, the SEC recently, in the beginning of 2020, did put out specific guidance on cybersecurity measures that are relevant for investment advisors. It's fairly detailed guidance, and I'm not sure that we have time to go into every subtopic that the SEC provided, but just to provide some examples, the SEC is going to expect advisors to take pretty detailed stock of the information that they collect and how it's secured. The SEC these days will be focused on remote access, especially because a significant part of any advisor's workforce these days probably is continuing to work remotely. And the SEC also expects advisors to understand how all of their vendors and counterparties are dealing with cybersecurity issues as well.
Sara, what about some of the basic concerns that all employers are having, whether it's social distancing or knowing how to make an office safe for their employees?
Yeah, of course. The first thing employers need to do is realize that post-COVID, at least in the near term, is going to look different than what the normal office looked like. And coming to that realization is critical. But even beyond that is notifying employees of your plans and of your expectations. Understanding what employees' concerns are will help you adjust to them and help you better plan for returning to the office if you aren't back already. You also need to train employees on COVID-19. Things like coming to the office, social distancing. We all know the phrase social distancing, but did you know that the CDC has recently revised the guidance to say that if you are in close contact with someone over the span of 48 hours, a total of 15 minutes, that is enough for close contact. So it could be a minute here, it could be 2 minutes there, 30 seconds here. All of that added together gives you close contact for CDC regulations.
Interesting. So there's a sort of a new cumulative approach to what it means to be in close contact with someone.
Absolutely, right. And when we're thinking about health and safety, there's a lot that goes into planning the return to the office. First, you want to tell employees, as I said earlier, about the significant efforts that you are undertaking. Whether it's installing plexiglass barriers, whether it's putting stickers behind door handles reminding employees to wash their hands after use. Every little step that employees understand that you're taking efforts to improve the workplace for them will improve the office morale, which will make returning to work much easier for everyone.
We have little pillows in our office saying, here's where you should actually sit. You can't necessarily squeeze in like we used to.
Exactly. Things like using tape to X off where you can't sit any longer, or pillows. I love the idea of pillows, although good luck washing those pillows. Second, you want to clearly communicate the anticipated changes and the requirements prior to employees returning to work. Things like temperature checks, things like whether it's an app or whether it's online that they're going in and certifying that they don't have the symptoms prior to returning to work. Employees need to know what's expected of them. You also should be reinforcing your sick leave policies. Employees need to be reminded that if they're sick, they should stay home. There are a lot of changes in the law here, a lot of local changes that you need to be aware of to make sure that your policies are compliant and that you're providing sufficient sick leave for employees.
What about if the employee just doesn't want to come in? Is that risk aversion something that needs to be reflected in employee manuals?
We have seen many employers struggle with that concept of employees who don't want to return to work. You should ask yourself, do you have a legal obligation to accommodate the request? Perhaps you didn't before, but the landscape looks different now. So you need to be thinking about whether you need to engage in the interactive process. And I know that's a phrase that many people shy away from.
Interactive process, without going in depth too much, can you give a quick gloss on what that is?
Sure. So you have to engage in a conversation with the employee to determine whether what they're asking you to do is something that you can reasonably accommodate. Can you change your job or the job that employee is performing to be able to accommodate that employee's needs? Does it become an undue hardship? Working virtually before could be seen as an undue hardship. Today, working virtually is a very different world, and so you really do need to look at big picture. Can you accommodate it? If you do decide to accommodate a virtual work from home, but you know you don't want to do that long term, it is a best practice to memorialize that expectation in writing with employees so that there is no expectation that they will be working virtually indefinitely. And one further thing, remember that when you're making accommodations like this, one accommodation for one individual really does set a precedent, and you need to be aware that other employees will expect the same thing. And if you don't offer the same accommodation, you need to have a really good reason why.
And by that, you mean perhaps the company would need to memorialize as well the justification. Perhaps this employee is client facing, or this employee needs to be in the office to do their responsibilities because why?
Yeah, absolutely. It's memorializing why are you making the distinction. A lot of employers are going through this process right now when they're saying which employees need to be back in the office first. Is the accounting department really one that can work remotely more often? And why is that? It's because a lot more of their job might be on the computer and less in-person FaceTime. Whereas you have a sales manager who, sure, right now working via Zoom is expected or even encouraged, but when things are hopefully at some point 100% back to normal, that sales manager that you expect to be in person really needs to return in person because that's their job. That's an essential function of their job.
Sara raises a good point that the events over the last year are requiring employers generally, but from my perspective, investment advisors specifically, to revisit policies and procedures that they have in place. And for an investment advisor, there's a requirement that your policies and procedures that are intended to comply with the Advisors Act are updated at least annually. And at this point, I would think that the SEC is going to expect COVID-specific issues to be addressed in those policies and procedures.
As we think about what the office looks like in the new norm, many employers are questioning whether they need as much real estate. Are the office spaces that they currently have sufficient? Is it too much? But when you think about social distancing and the trend to greater amount of spaces where you have shared spaces, I think some of that is vulnerable to reverting back to individual offices. So I think the real estate market as a whole has some challenges ahead of what will expectations be from tenants and what will those lease documents look like? What sort of force majeure contract provisions are going to be included to make sure that both parties are adequately protected?
From my perspective, to the extent that investment advisors personnel do go back to the office and things start to look like normal, whatever the new normal is, I think to some extent the ability of personnel to work remotely is something that we're going to continue to see for some period of time. And the SEC is going to continue to focus on making sure that advisors do that well. I think we're going to also start to see an increased level of diligence from investors on advisors and their personnel. And there may be some expectation that advisors actually disclose when there may be health issues for the key personnel of an advisor. And obviously there's an interplay there with Sara's area of expertise. And I assume that there has to be some balance struck between a contractual obligation to provide information to investors in a fund versus the privacy rights of the individual involved.
From an employment perspective, having COVID does not automatically qualify you as a disabled person. There has to be more than just COVID itself. So we know there are many severe cases that have long-lasting consequences. We do not know at this point whether or not the symptoms and the underlying condition is sufficient to trigger an ADA accommodation request. Nor do we really know long-term implications on key person provisions and governing documents. I guess I would leave that to IRA and the particular circumstances that each case presents.
Well, Sara, Ira, thank you so much for taking the time today. And perhaps if we have some additional questions, maybe we'll welcome you back for another conversation.